Imagine this, it's 3 a.m. on a deserted highway. A car swerves violently across 3 lanes, collides with a barrier, and flips twice before coming to rest. Inside, the driver is found unharmed but disoriented. When police arrive, they make a startling discovery: the driver wasn't intoxicated, texting, or even conscious at the time of the crash. They were asleep at the wheel. And in a courtroom 6 months later, they walk away with no criminal conviction. How is this possible? This scenario plays out more often than you might think, thanks to a controversial legal principle that treats sleep-related crashes differently than other forms of dangerous driving. While drunk drivers face prison sentences and lifetime consequences, sleeping drivers often avoid criminal liability entirely through what legal experts call the automatism defense. The automatism defense: when your body betrays you. The legal loophole centers on the concept of automatism, a state where a person acts without conscious control or awareness. In many jurisdictions, including parts of the United States, Canada, and the United Kingdom, if a driver can prove they were in a state of non-insane automatism, meaning not caused by a mental disorder, they may be acquitted of dangerous driving charges. There's a fundamental legal principle at play here, explains criminal law professor Dr. Eleanor Vance. For someone to be criminally responsible, they must have mens rea, a guilty mind. They must have intended to commit a crime or been reckless about the risks. If someone falls asleep without warning, they arguably lack that mental state. The defense typically requires proving the driver had no warning they were about to fall asleep. They hadn't engaged in reckless behavior that increased sleepiness. The sleep episode was sudden and unexpected. The medical mystery of microsleeps. Complicating matters further is the phenomenon of microsleeps, brief, uncontrollable episodes of sleep lasting from a fraction of a second up to 30 seconds. During microsleeps, the brain disengages from the environment, and the person becomes temporarily unconscious while their eyes may remain open. Dr. Marcus Thorne, a sleep specialist at Stanford Sleep Center, explains, microsleeps are particularly dangerous because they occur without warning. One moment you're driving, the next your brain has essentially switched off. You might not even realize it happened until you jerk awake or, tragically, until you've caused an accident. The legal system struggles with microsleep cases because they exist in a gray area between conscious recklessness and complete unconsciousness. How can we assign criminal responsibility to someone whose brain literally shut down without their knowledge or consent? The burden of proof: who's responsible for recognizing sleepiness? Central to the legal controversy is determining when a driver should have known they were too tired to drive. Unlike blood alcohol concentration, which provides a clear, measurable standard for impairment, sleepiness lacks an objective measurement tool. Courts typically consider factors including hours of wakefulness prior to driving, sleep quantity and quality in preceding days, whether the driver ignored obvious signs of fatigue, yawning, heavy eyelids, lane drifting, whether they consumed medications known to cause drowsiness. However, proving what a driver should have known about their own fatigue level is notoriously difficult. Sleep debt accumulates gradually, and many people develop a distorted perception of their own alertness. We have a cultural blind spot about sleep, says Dr. Thorne. People brag about functioning on 4 hours of sleep as if it's a badge of honor. But study after study shows that after 20 hours awake, your cognitive impairment is equivalent to a 0.08% blood alcohol level, legally drunk in most places. The victim's perspective: when justice sleeps through the trial. For crash victims and their families, seeing sleeping drivers avoid conviction feels like a profound injustice. Take the case of Sarah Jennings *, whose 17-year-old daughter was killed when a commercial truck driver fell asleep and crossed into oncoming traffic. The driver admitted he'd been awake for 28 hours straight, Sarah recounts, her voice trembling even years later. He said he was trying to meet a delivery deadline. At trial, his lawyer argued he didn't intend to fall asleep, so it wasn't criminal. He walked away with a traffic ticket. My daughter's life was worth less than a speeding ticket. This emotional disconnect between legal technicalities and human consequences fuels calls for reform. Advocacy groups like Awake at the Wheel argue that choosing to drive while severely fatigued should be treated with the same seriousness as drunk driving. We don't accept "I didn't mean to get drunk" as a defense, says the group's founder, Michael Torres. Why do we accept "I didn't mean to fall asleep"? Both represent conscious choices to operate a vehicle while impaired. The corporate enablers: when profit trumps safety. The loophole has particularly troubling implications in commercial transportation. Trucking companies facing tight deadlines have sometimes encouraged drivers to push beyond safe limits, knowing that if an accident occurs, the automatism defense might protect both driver and company from criminal liability. There's an economic incentive structure that's fundamentally broken, says transportation safety expert Linda Park. Fines for violating hours of service regulations are often treated as just a cost of doing business. Without meaningful criminal consequences for companies that knowingly allow fatigued driving, the calculus won't change. Recent high-profile cases have seen prosecutors attempting to charge both drivers and their employers with manslaughter or negligent homicide, but convictions remain rare and difficult to obtain. The scientific reality: sleep attacks aren't always predictable. Despite the compelling arguments for stricter liability, sleep scientists caution against oversimplification. Certain medical conditions like sleep apnea, narcolepsy, or previously undiagnosed seizure disorders can cause sudden, unpredictable sleep episodes. For a small percentage of the population, the first symptom of a sleep disorder might be falling asleep at the wheel, explains Dr. Thorne. If someone has undiagnosed severe sleep apnea, they might get what appears to be a full night's sleep but actually be dangerously fatigued. Punishing them as criminals when they lack both intent and knowledge seems unjust. This medical reality creates a genuine dilemma. How do we distinguish between reckless disregard for safety and genuine medical misfortune? Global approaches: how other countries handle sleeping drivers. The legal treatment of fatigue-related crashes varies significantly worldwide. Australia: several states have implemented specific fatigue driving offenses with penalties similar to drunk driving. Victoria's Driver Reviver program provides free rest stops during holiday periods. United Kingdom: courts have increasingly rejected the automatism defense for drivers who ignored clear warning signs. In a landmark 2019 case, a driver who crashed after being awake 24 hours received a 4-year prison sentence for causing death by dangerous driving. Japan: the country has implemented both criminal penalties and a unique sleeping driver alert system in some vehicles that monitors steering patterns for signs of drowsiness. Germany: the Autobahn features rumble strips specifically designed to wake dozing drivers, coupled with strict liability for accidents caused by fatigue. These international approaches suggest a growing recognition that fatigue deserves specific legal attention rather than being squeezed into existing frameworks designed for other impairments. Technological solutions: can technology close the loophole? As the legal system grapples with these questions, technology is advancing to prevent fatigue-related crashes before they occur. Modern systems include driver monitoring cameras, using facial recognition to detect eye closure, yawning, and head nodding. Steering pattern analysis, identifying the microcorrections characteristic of drowsy driving. Lane departure warnings, alerting drivers when they drift without signaling. Biometric sensors, measuring physiological indicators like heart rate variability that correlate with fatigue. Technology won't solve the legal questions, says automotive safety engineer David Chen, but it's changing the evidentiary landscape. If a car system shows 15 fatigue warnings in the hour before a crash, it becomes much harder to claim the driver had no warning. The path forward: reforming laws without creating injustice. Legal scholars and safety advocates are increasingly calling for a middle path that recognizes both the dangers of fatigued driving and the complexities of sleep science. Proposed reforms include creating a specific offense of dangerous driving while fatigued with clear, evidence-based standards for what constitutes reckless disregard for fatigue. Implementing graduated penalties that distinguish between medically unexpected sleep episodes and willful disregard of obvious fatigue. Mandating sleep disorder screening for drivers involved in serious fatigue-related crashes. Increasing corporate liability for employers who knowingly allow or encourage fatigued driving. Improving public education about sleep needs and the dangers of driving while tired. The goal shouldn't be to criminalize sleep disorders, argues Professor Vance. But we need to create a legal framework that recognizes driving while severely fatigued as a conscious choice that carries serious responsibility, just like drinking before driving. Waking up to the reality. The loophole that lets sleeping drivers walk free exists at the intersection of three uncomfortable truths: our legal system privileges intention over outcome in criminal matters, our society undervalues sleep, and our biology sometimes betrays us without warning. As crash statistics continue to show fatigue as a factor in up to 20% of serious accidents, pressure for reform is growing. The challenge lies in crafting laws that hold people accountable for reckless choices without punishing those who experience genuine medical events beyond their control. Perhaps the most profound change needed isn't legal but cultural. In a world that glorifies busyness and treats sleep as optional, we've created conditions where falling asleep at the wheel is almost inevitable for some. Until we value rest as much as productivity, and until we recognize that driving while exhausted is as socially unacceptable as driving drunk, the legal loophole will remain, and people will continue to pay for it with their lives. The next time you consider pushing through fatigue to make that late-night drive, remember, the law might forgive you if you crash, but the victims of your accident won't have that luxury. And no legal technicality can restore a life once lost to a preventable moment of unconsciousness.